My name is Marty Mascari. I am a contractor with the North Central Texas Area Agency on the Aging and the North Central Texas Aging and Disability Resource Center, or ADRC, both of which are under the umbrella of the North Central Texas Council of Governments in the greater Dallas-Fort Worth area. We are blessed once again to have our partners at the North Texas Fair Housing Center here today. And today, the topic is housing discrimination case studies, disabilities, or just, I guess, disability case studies. And so before we get started, if we could, we're gonna advance a slide, and I'm gonna talk about those of you that are joining us for continuing education units or CEUs. I am set up to provide CEUs for licensed social workers and licensed professional counselors in the state of Texas. For those of you with other licenses in Texas or licenses outside of Texas, you're more than welcome to fill out the form and ask for either a CEU certificate or a certificate of attendance and present that to your jurisdiction. But just please understand that those are the only two licenses I'm set up to provide them for in the state of Texas. So it's going to be totally up to your jurisdiction whether they're going to accept those or not. But you're welcome to go through the process, and I'd be happy to send you a certificate. Just so you know, I'm quite a bit behind right now. I've had some health issues, and so I'm trying to catch up again. And so I certainly apologize. But today's webinar, in order to be eligible for the either certificate of attendance or CEUs, you must attend the entire live webinar. It's good for an hour and a half's worth of CEUs. You must complete the Google evaluation survey that should pop up at the end of, or as you close out of Zoom today. It should give you an option to go to that. You can either do it there, or I will send out a follow-up email with that link as well. Once you get that, like I said, it will have the link in it. You'll have a week to complete that till August the 2nd. And then after that, right now I'm going to need about 4 weeks of time to be able to get get those CEU certificates back to you. So I'm going to turn it over now. Francis Espinoza is the Executive Director of the North Texas Fair Housing Center. And I'm going to turn it over to you, Francis. And I think you're on mute.
It would help if I unmuted myself, right?
There you go.
So Marty, I'm only on one screen this morning. Can you see the slides okay?
I can see the slides. I can see the slides just fine.
Okay, but I'm also seeing the actual Zoom. Can you see the toolbar right going across it?
The toolbar at the bottom of your screen, I can see but it's not a problem unless you're concerned about it. It shows the bottom. It shows all of your icons at the bottom. Now it shows just the slides.
Okay, but is it showing? Because on my screen, the Zoom box is like your Zoom is right in the middle of the screen. That's not blocking the slides for you, right?
Not for me. Not for
me.
Good.
Mine
is over to the side, and that's just my view. But I think if in the top right-hand corner, I think people can click on view and decide how they want those to show up, what part of the screen, or if they even want them to show up at all.
Okay. Thank you. I just
it.
wanted to make sure it wasn't right in the middle of the slide.
No, it's not.
Okay, so good morning, everyone. As Marty said, my name is Francis Espinoza, and I'm the Executive Director of the North Texas Fair Housing Center. And today I'm going to present some case studies on disability because I think it's really important to know where the different provisions of the disability law come from, because the law doesn't actually have a lot of language in it. It talks about reasonable accommodations and modifications, but we've gotten a lot of, definition of what that means through case law. And it's really helpful, for fair housing advocates like me to use the case law if we're trying to advocate for a client to get a specific accommodation. So my presentation today is going to focus on the accommodations, which are exceptions or asking to have a rule, policy, or procedure waived because of a disability. We're not going to talk about modifications, which are changes in the physical structure. And those are honestly, those are a lot easier to deal with. It really is the changes to rules, policies, and procedures that gives us a lot of gray area. So, it really is a case-by-case analysis when you look at that. And so because of that, that's why we often look to case law to figure out, has this specific accommodation been requested and gotten, into a court. So that's kind of what the point of view is going to be today. Okay, so just a quick refresher. The disability provision of the Fair Housing Act was added to the law in 1988, and technically it's called the Fair Housing Amendments Act of 1988. And that added disability, and it also added familial status, which specifically is protection for people who have children under the age of 18. I'm sorry, can you hear that? Sorry, my dogs are going a little bit crazy in the other room.
I can't really hear it.
Okay, good. Okay. So the disability provision, like I said, was passed in 1988. And if you wanted to look that up, it's if you put into your Google search 42 US Code section 3604 F3B, you'll see what the law has to say about disability and accommodations. So it requires housing providers to make reasonable accommodations, which, like I said, are exceptions or waiving rules, policies, practices, or changing services due to somebody's disability when they ask for an accommodation. And the goal of that is to give the person with a disability equal use and enjoyment of a dwelling. So we want people with disabilities to be able to enjoy their housing the same as people who don't have disabilities. So the requirement, sometimes I get housing providers a lot telling me that they don't have to abide by the law because their understanding of the law is that it only protects people that are in public or government subsidized housing. And all types of housing are covered. So the requirement to make an accommodation applies to housing authorities, affordable housing, government subsidized housing, and all private housing providers, which I refer to private housing providers a lot as market rate housing. And so it's going to apply to all housing providers. The one exception to this is if somebody owns 4 or less units and lives in one of them and rents the others, then they could be exempt from the Fair Housing Act. So just be, that exception doesn't really come into play very often at all, especially here in Texas, where you have a lot of the housing providers own very large apartment buildings. So this is that exception is more for kind of the mom and pop housing provider that might own their own home and have a duplex or a triplex that they rent out. They could be exempt from the fair housing laws, but if they make any statements of discrimination or place any discriminatory ads, then there are other portions of the Fair Housing Act that would apply to them. So, the exception is very narrow. Okay, so I'm going to talk about the most common reasonable accommodations that people ask for. And the first one is service and emotional support animals. So I thought it was important to highlight cases that are HUD cases. So HUD has actually brought a lot of these cases. And so when they do, the plaintiff is Secretary of HUD, and Secretary of HUD is suing a housing provider. And so these are administrative law judge decisions. So when a case is filed, when somebody files a complaint with HUD and it goes through their investigation and the investigators are not able to settle the case, or what they call conciliate the case, which is kind of like a mediation. If they do find evidence of discrimination, it could go to attorneys, and typically, sometimes it's attorneys from HUD, and sometimes it could be attorneys from Department of Justice, and they would represent HUD in the claim. So there is a person that was affected, but when HUD brings the case, they bring it on behalf of HUD. And so it started with a person making a complaint, but then it goes to, HUD is the one that actually brings the lawsuit. And most commonly, HUD brings cases in the administrative courts, which aren't really courts. It's an administrative law judge, and they bring it in front of the judge, and they do everything that would happen in a court. But it's an administrative decision because HUD is a government authority, and so they take their cases many times to the administrative law judges to make decisions. Sometimes they'll take it, if it's a really, really large case, they will take it to the federal courts. So let's talk about Secretary of HUD versus River Bay Corporation. So if you Google that case and that number, you could find the actual decision if you're interested in reading it. Oops, what happened? So this is River Bay Corporation. So River Bay Corporation was the housing provider. And this is a straightforward case. Somebody asked for an accommodation. The apartment had a no pet policy. And so they denied it. They denied the request to have a pet or to have an emotional support animal. And so what this case stands for is the right to be exempt from a no pet policy. So this is just the basic case that supports the accommodation to have an emotional support animal. It also stands for the proposition that their tenants who have an emotional support animal and request the accommodation to be exempt from the no pet policy have the right to not be evicted. In this case, the person had an emotional support animal, requested an exception to the no pet policy because the ESA they had was due to a disability. And the housing provider, instead of acting on it, enforced their no pet policy and then moved quickly to try to evict the tenant. So this is one, like I said, this is one of the basic, it stands for the basic provision that we always talk about for emotional service support animals under the law, which is you have a right to an accommodation as to ask for an exception to a no pet policy, and a right to not be evicted because you have an emotional service animal. So one of the things that we, tell our clients, ideally, if you have a service or emotional support animal, that you would request an exception to a no pet policy or an exception to pet rent before you bring the animal into the housing. So, somebody who is going to apply at an apartment, on the application, they should state that they have an animal and to make sure at that point to say it's an emotional support animal or service animal and not a pet. And housing provider has the right to ask for documentation. So a letter from a doctor, for example, but they have to grant that exception to the no pet policy. That's ideal if the person asks for the exception before they bring the animal into the housing, like I said, but in most cases, that's not what happens. Our clients, they have the emotional support animal, and typically what happens is the housing provider learns of the pet being in the household and considers it a pet and gives the tenant a notice that they have to start paying, that they owe a pet deposit and have to start paying pet rent. So Secretary of HUD versus Dutra, that case stands for if a tenant brings an animal into the household without first seeking the landlord's permission in an accommodation and an exception to a no pet policy, for example, or to be exempt from a pet deposit, that's not grounds for a landlord to reject the tenant's accommodation. So the landlord can't turn around and say, well, you know, you brought this animal in and now we're saying that it's a emotional support animal or service animal. I'm going to evict you for that reason. So this case said, landlord, you cannot do that. You can't use that as an excuse. You still have to deal with the accommodation request separately and decide that whether or not to make the accommodation. And in most cases, the landlord has to make the accommodation. It's not, there's a very, very high threshold that a landlord would have to meet to deny an accommodation request. So I think that's a really important case because, like I said, this happens all the time with our clients. You know, we would like our clients to deal with all that red tape, ask for the accommodation, give the doctor's letter if it's required, make sure that all of that is documented in their lease before they even move in, but that doesn't always happen. And so I think this case is really important because they can't use that as a reason to evict somebody. And sometimes they start an eviction, they learn of the animal being in the household, they start the eviction, and the person then says, you know, this is an emotional support animal. So that should actually the accommodation request should take precedence. Oopsie. The accommodation request should take precedence, and they should deal with that and dismiss the eviction or not evict the person. So I think that's really important. Another case, so a lot of times, you know, the most typical emotional support animal is a cat or a dog, but there are other types of emotional support animals, and you know, the ones that I've helped people get exceptions for or get accommodation requests for: cats, dogs. I've actually done a lot of requests for birds, and then for rodents, like an emotional support rat. Those are the ones that I've done, but you know, it could be almost any type of animal that is legal to have. So, you know, an animal that isn't legal under a local city's ordinances wouldn't be something you could request an accommodation for. So, or an animal that you're not supposed to have under the law, like, you know, I had a colleague who rented office space next to us several years ago, and he had, living in his garage, he had a tiger living in his garage. And apparently Texas, of all the states, Texas has the most people who own illegal wild animals, which is really interesting. But anyways, something like that, you couldn't ask for an accommodation to have, because you really shouldn't have one of those in your home. So the next case is Janusz versus Charities Housing Development Corporation. And what that case stood for is you can't accept one animal or prefer one type of animal over another. So in that case, the housing provider was okay with an emotional support animal being a dog, but the person in this case had 2 birds and a cat. And the housing provider told her when she requested the accommodation, no, you can't have those. You can't have those types of animals as an accommodation. So the other important thing that came out of this case is that the tenant's emotional bond with her animals made the landlord's demand to use another type of animal insufficient. So we argue this point all the time. So in cases where a tenant will have an emotional support animal and haven't requested permission before they got the animal, or maybe has had the animal for a while, maybe has been living in the apartment a year or 2 years, has had this emotional support animal all along, but landlord just found out about it. One of the arguments we make is that, you know, the tenant's emotional bond with if they had to get rid of the pet or the emotional support animal, it might exacerbate the symptoms of their disability because they've already established a bond. You know, this is their ESA, this is their baby. They've had this emotional support animal for X number of years, and to ask them to get rid of it would just make the symptoms of their disability worse. And that's an argument that is supported by the court, that if they have this emotional bond with the animal, you know, in this particular case, the landlord couldn't ask the woman to get rid of her 2 birds and a cat to get a dog, because she had these two birds and the cat for quite a number of years. And so it wasn't sufficient for the landlord to use as an excuse that he was fine with letting her have a dog, but he didn't want cats and birds in the house because he thought birds shouldn't be in the house, and he thought that the cats would cause more damage because, you know, they typically scratch stuff if they have, you know, typically they'll scratch like the person's furniture. They won't really damage the unit, but that was the landlord's excuse, and the court found that it was not sufficient. Are there any questions in the chat about service and emotional support animals that we can address before we move to the next topic?
I didn't see any. No, I did not see questions. But please, you all, please put your questions in the Q&A or the chat if you have questions, and we'll try to answer them. And you know, I realize I think she's going to touch on different types of cases, and so support animals was kind of the first set of cases. And so if you have any questions, like I said, please add them to the chat.
Okay, and we'll look at questions at the very end too to make sure we didn't miss anyone. Okay, so the next most commonly requested accommodation is to have a transfer to a different unit. And there are several cases I wanted to highlight, one actually in Texas. And I tried to pick cases that either were HUD cases, because HUD's interpretation of the fair housing laws can be applied in any state, or I tried to pick cases that were specific to Texas, but there just aren't a lot of cases that originate in Texas that we use to define what the disability protection of the fair housing law means. Okay, so for unit transfers, the case Roseboro versus Cottonwood Apartments is important. So this is the basic case that says if a landlord has a no transfer policy, a tenant can still request an accommodation to transfer to a different unit that's more accessible for them. So this is kind of your basic case that says an accommodation to transfer can be asked for. And another thing that kind of developed from that case law is also exemption to a transfer fee. So if an apartment has a transfer fee that they apply, the person can request a waiver of that as well. And typically with accommodations, they can't be financial accommodations. But in this case, this is more of an administrative fee that they charge for somebody to transfer. So a person can ask to be exempt from that transfer fee. So this is the next case is really interesting. United States versus Housing Authority of San Antonio. And if you look in the development of fair housing law, you'll find in all the different areas, most of the strongest cases and most of the cases we look to define what fair housing law means come from cases where the housing authorities are sued. And that again and that's why housing authorities are also have to abide by the fair housing laws. So in this case, the person asked for a transfer to the building did have an elevator. It was a 3-story building and it did have an elevator. But the tenant's unit was not very close to the elevator. So he asked for a transfer to another unit. He wanted a first floor unit, and it was the first floor unit that was open was close to the elevator. And so what this case stands for is that a building having an elevator doesn't mean the person can't ask for a transfer to a more accessible unit as an accommodation to a disability. So I think that's really important because typically we think that the transfer provision is for buildings that don't have elevators. And if somebody lives, say, just even in a 2-story walk up and they have a unit on the 2nd floor, and then they become disabled while they're living there, for example, they can ask for an accommodation to transfer to the 1st floor. But this case I wanted to include because interestingly, even if there is an elevator, if the unit transfer makes the unit more accessible for the person with a disability, then it has to be granted regardless of whether there's an elevator in the building. The next one that I think is really important is Manor Park Apartments versus Garrison. So this stands for that the accommodation requests, they're not limited to the people who are mobility impaired, that there can be other reasons why somebody wants to transfer to a unit. So they're not requesting an accommodation to transfer to a unit that's more accessible because, for example, they are using a walker or are now in a wheelchair. So one example is, and the case actually talked about this, that a tenant who has claustrophobia could request an accommodation to transfer to a larger unit. So I think one caveat here, though, is that the larger unit is probably going to have a higher rent. And so the person who's asking for the transfer needs to understand that and will not be able to get a waiver of the additional rent amount, because typically if you're in a 1-bedroom, a 2-bedroom is going to cost more in monthly rent. And so the person has to be able to, has to accept that and has to be able to afford to pay that additional rent. But if the reason for the transfer is a disability such as claustrophobia, somebody can ask for a larger unit. The other one I think that's really important is a tenant might need a larger unit because they have a caregiver. And so we've had clients who have had live-in caregivers because they need assistance with specific things kind of on an around-the-clock basis. And so they live in a 1-bedroom but need a bigger unit to have their caregiver live with them. And so they can request an accommodation for a larger unit. I think we've had a lot of difficulty in getting the housing authorities to abide by this, though, because somebody, for example, who has a voucher, a housing choice voucher for only a 1-bedroom apartment, they can ask of the housing authority for an accommodation to get a 2-bedroom voucher so that they can have their live-in caregiver. And that has been a real, and they should grant that request, but that's been a really big hurdle for us because the housing authorities don't want to do it because it's going to cost them more in the 2-bedroom voucher than it does for the 1-bedroom voucher. And a lot of times they may not have a 2-bedroom voucher available because, as we all know, the wait lists for even getting a housing choice voucher are extremely long, and people stay on these wait lists 5, 6, 7, even some I've heard up to 10 years. So they may not have one readily available. And so that, when that is the case, they deny the accommodation, which they really, under the law, they can't deny that accommodation. And so that's something to be aware of, that, a tenant can ask for the larger unit due to needing a caregiver. And they can also ask the housing authority for a 2-bedroom voucher if they just have a 1-bedroom voucher, for example. Okay. So the next most common accommodation is regarding rent, and typically that's going to be rent payments and how they're processed or how they're submitted by the tenant. And so HUD and the Department of Justice several years ago issued a joint statement, and it's a really good memo. I don't know, it's probably like, what is it, Marty? Do you remember? It's like 12 pages or something. But in it, it also talks about the most common accommodations that people request. And the memo actually has some really good examples in it. So, it talks about, these examples which you can apply to real life, which I think is really helpful. And a lot of times when we're assisting people who are needing an accommodation and they've asked for it on their own already and it's been denied by the housing provider, one of the things that we do, besides call the housing provider and explain the laws, we'll send them this joint statement by HUD and DOJ. And so I think, and it really helps to kind of push, the point home that they need to be granting this accommodation. So in the joint statement, one of the examples they use is a tenant who is afraid to leave her unit, doesn't feel safe, just, doesn't go out for anything, gets groceries delivered, does everything on the computer or by mail. And her apartment requires her to deliver her rent payment in person. The joint statement example states that she should be allowed to mail her rent check in instead of delivering in person. So this example probably doesn't apply to a lot of the cases or a lot of Texas, because these really big apartments, a lot of apartments have a portal now. And so you can process your rent and everything through the portal, which actually is more accessible, can be more accessible to somebody with a disability to be able to do everything on the computer and not have to go anywhere or, deliver their rent. It also means, rent checks can't be lost, for example. So, but that's an example of the HUD joint statement. The HUD and DOJ joint statement has in it. And I believe if you search for HUD and DOJ joint statement on Google, it'll come up. I think we might have it on our North Texas Fair Housing Center resource page. But it's a really good handy document to have on hand if you work with people with disabilities and your clients need to request accommodations. So the other case I wanted to highlight, because this issue kind of came up a lot during COVID, because folks weren't able to pay their rent and applied for rental assistance programs where the program paid the rent directly and paid any back rent directly to the housing provider. It didn't go to the tenant, and then tenant to the housing provider, went directly to the housing provider. So this case, Department of Fair Employment and Housing case, said the landlord must accept a third-party check for rental assistance if the tenant is receiving the check due to their disability. And so that's the one piece that, you know, wouldn't apply to everybody who needs their rent paid by a third party. It has to be their rent being paid by a third party, and it's somehow related to the person's disability. But I think that you can argue for a third party check being accepted, I think, in most circumstances. And we've been really successful in getting housing providers to accept third party checks to get people caught up on their rent, or to pay their rent for a few months while they're getting on their feet, for example. And so I think this is a valid accommodation that somebody could ask for, and it isn't something housing providers typically approve with the tenant's request. And so a lot of times an advocate needs to get involved in order for the landlord to accept that third party check. But that is something that, you know, we advocates can request that they accept this, because typically it's only for a temporary amount of time. It's not forever. So one of the interesting things is we've asked for, the North Texas Fair Housing Center has gotten housing providers to change rent due dates for folks. And, you know, our most common type of change of rent due date case is folks who are on disability. And I don't remember when the disability payments are made, but some people don't get their disability payments between the 1st and the 3rd of the month, which is typically when rent is due, and due without and you could pay within the 1st to the 3rd without getting a late fee added to your rent. And so we've been successful in advocating that the apartment change the rent due date, and change it so that to a date that makes it so that the person doesn't have a late fee every single month. But what's really interesting is that we've been successful getting this accommodation, but there actually is no case law specifically on this issue. So I just wanted to make people aware of that. So this is one of those things where, you know, we like it when there's case law behind us, because, you know, we ask for the accommodation at first, we kind of try to educate the landlord. And then if we get pushback, that's when we start sharing the law with them, the joint statement from HUD, kind of pushing back on them that, you know, this is the law and you have to abide by the law. But just be aware that this change of rent due date, there isn't any case law specifically on that topic, but I think it's, if there ever was, I think the person would probably be successful in litigation, because, you know, this is a reasonable accommodation that doesn't require the landlord to incur any losses. And that's the main issue that the courts look at, is granting this accommodation going to cause any kind of financial issues for the housing provider? Okay. So parking spaces, that is another one of the top requests for accommodations. So there actually is a CFR that talks about parking spaces. So if you look at 24 CFR section 100.204B, that will actually talk about parking spaces as an accommodation. You can also look at the case, a HUD case, Secretary of HUD versus Jankowski, which talks about parking spaces. In the HUD and DOJ joint statement that I mentioned earlier, there's a really good example in there about parking spaces being an accommodation. And then I wanted to talk a little bit, so all of these cases stand for a tenant with a mobility impairment is entitled to request a parking space, and there's several ways that this can be used. They can get a shortcut to be first on a waiting list for parking. They can request to have a preference when a parking space near their unit becomes available. They can request a designated parking space if parking is on a first come, first served basis. So a lot of times we get pushback from housing providers that, parking is first come, first served. There are a few spaces that are marked handicapped, but those are also first come, first served. And typically there's more people that need them and have the placards than there are spaces. And so one of the accommodations that we can request is not necessarily that another space be marked with the handicap symbol, but we can actually request that a space be reserved and dedicated to a specific person as an accommodation. So I wanted to talk about Southern California Housing Rights Center versus Los Feliz Towers, because that was actually one of the cases that I was involved in when I was in California. And Los Feliz Towers is this really big high rise in a really affluent part of LA, that big condo development. And our client had MS, and she had a van that she could load herself into and out of, and she used a wheelchair, but she could load herself into and out of her van. And that was what she needed and wanted, because she wanted to preserve her, she wanted to be as independent as she could be, to take herself, to the grocery store or shopping. And so she asked for them. They did not have a space designated for, they did have spaces designated for handicap, but they didn't have any spaces that were for an accessible van. And you all probably know that the spaces for a van, next to them, they have a big space that's hashed out, because that way the person can load and unload the van themselves into and out of the van. And so they didn't have that. So what she asked for was if they could just give her 2 spaces so that she would have the one to park in, and that the second one, no one would ever park in, because she needed that additional space to get into and out of her van. And they denied her request. And then we got involved and asked for we sent a demand letter and asked for, kind of gave them one last chance to give us the accommodation request. And they denied that as well, because their attorney for the HOA gave them really awful advice and told them they didn't have to do it. And so they refused to settle. And so we filed in federal court. And ultimately, this case settled for almost $200,000, because to cover attorney's fees and for the damages to our client, because, their attorney not only gave them bad advice, but then kind of dug into his position and kept trying to fight us until finally, we got to court. And there was a mandatory, in federal court, there's a mandatory settlement conference at some point in the process. And the judge was like, you need to get this done. You need to settle this. And so we were able to settle the case, and our client got the spaces that she needed and a damages award. And this was a condo, so it was a homeowners association. So what they did, and people who lived there were so upset, because, I'm sorry, can you hear all that barking? I might have to go calm down
I don't.
Okay, good.
So,
I'm far enough away from them, but I can hear it. And so what's interesting about, it being an HOA, they didn't have any, they had barely any reserves. And so they apportioned, and because their insurance declined to cover part of the award. I think their insurance only paid for the attorney's fees and their own attorney's fees, but didn't pay any of ours or the damages. So in order to settle the case, they actually took the total amount and did a special assessment on all of their homeowners of a portion of the award. which is kind of crazy. So those poor homeowners, and this is, one of those things where if you live in a condo and you have an HOA, just be really aware of what they do and that they're following the law, because all of these homeowners were on the hook for their portion of the settlement because their HOA didn't abide by the law and then hired an attorney that didn't know what he was doing either. So just kind of a, food for thought. Okay. Next most common type of request is for caregivers. And there's a lot of cases on this issue of having a caregiver. And so the first, it's actually in the CFR as well. So if you look at 24 CFR, and very few accommodations are in the CFRs. That's why we look to case law for a lot of the definition. But 24 CFR section 1982.316, we'll talk about caregivers as well if you want to review that. But I wanted to highlight some cases. So Boulder Meadows versus Seville. So this requires a housing authority to grant the accommodation of a live-in aid for a tenant with a disability. And I think that's the reason I added this case in is because, in the work that we do at North Texas Fair Housing Center, one of the real problems that we have is actually with the housing authorities and their treatment of people with disabilities, because they really have a poor record of granting accommodations for people with disabilities. And so, it's real difficult to, it's been real difficult for us to get them to grant accommodations. So I think which is why I included this case. So, they're also required to grant accommodations in the Fair Housing Act. The next case I have is QTOG versus Piney. So this is a very interesting case because the tenant needed 2 full-time caregivers. He was in end-stage renal failure. And rather than allow him to have the 2 full-time caregivers, the landlord moved to evict him because they saw that he had they thought or interpreted it as additional occupants. And so this case stands for, you can actually, if you have an attorney who knows what they're doing, you can actually get the eviction stopped because of a violation of the fair housing law. And so, but, the law itself, and for example, filing a discrimination complaint with HUD doesn't do that. It doesn't stop an eviction. So we always have to let folks know if they're in an eviction, filing a complaint with HUD is not going to stop that. But if you had an attorney to represent you, they could file an injunction with the federal court to get that eviction in the state court stopped until the issue of discrimination is determined. 20 CFR 100.203 stands for a landlord must waive the policy that prohibits non-tenants from accessing laundry rooms. So in this particular case, the person had a disability and wasn't able to use the laundry room. It just wasn't accessible for him. And the housing provider had a policy that non-tenants cannot use the laundry room, but he needed someone who didn't live there, so a friend, family member, to come in and do his laundry for him. And they tried to throw that person out of the laundry room. So the tenant had to apply for, or had to request an accommodation. And this CFR says that the person, that is a valid accommodation, that if a property has a policy of no tenants in common areas or specifically laundry room, they have to let a non-tenant use it if they're doing the laundry of a person with a disability who is a tenant. So we get the question sometimes about if somebody lives in a seniors only complex. For example, if they're grandparents, can they have their grandchild live in there? if they have to adopt their grandchild, can they move the grandchild into the apartment? And the answer to that is no, they can't, because the grandchild doesn't meet the age requirements. But I wanted to highlight this case, Kennedy versus Prescott Canyon Estates HOA, because it was a senior facility, and the parents wanted to add their son to their unit because he had a severe disability and needed to be in their care. And the son didn't meet the requirements of the property. He didn't meet the age requirements. But this case stands for that being an accommodation that the parents can ask for. So they can ask for a reasonable accommodation to add their son to their apartment if this, or a child to their apartment, even though they don't meet the complex's age requirements, if the child needs care due to their disability. So the difference here in, say, grandparents requesting to have their grandchild live there, there's not the disability factor in that scenario. They just need to, if the grandparents just need to adopt their grandchild, that isn't a permissible exception. Okay. And then I think, yes, the last topic that I wanted to cover is evictions of tenants with mental disabilities. And this is a really difficult area because, and I think it's not understood well by housing providers at all. And so the Fair Housing Act permits landlords to evict a tenant who they see as a direct threat to the health and safety of other tenants, or somebody who is causing substantial property damage due to their disability. There are some exceptions to this, though, and I think the joint statement by HUD and DOJ is really important here, because it does go into detail on mental disabilities. And the way I've described it to people is there should be, it's kind of like a second chance rule. So if the person has, for example, caused a health and safety issue to other tenants or has damaged property, say it's because they've gone off their medication. So if the person then promises or commits to staying on their medication, they should be given a second chance to continue their tenancy. As far as property damage, they're still required to pay for that if they've caused any damage to property. So the joint statement from HUD and DOJ talks about before evicting a tenant who poses a direct threat, a housing provider has to determine if there's any way to eliminate that threat. And that's the medication example. If the person only caused the direct threat because they went off their medication, and typically there's going to be some incident that happened, and if that person had been on their medication, if that incident would not have happened otherwise, and again they commit to going back on their medication and staying on it, then they should not be evicted. So one good example that I had actually in the cases that I've worked on is during COVID, I had a client who their medication wasn't readily available. I don't know if it was a supply chain issue or what was going on, but it wasn't available. The specific medication that she was on was not available. And due to this, the doctor didn't put her on anything else, any other type of medication to take the place of that. And due to this, she started, yelling at other tenants and just, doing a lot of things that scared the other tenants. She didn't physically harm anybody. She just would scream and yell at everybody, and the housing provider wanted to evict her. So we got involved and we worked with the housing provider, and we found, through the tenant as well, we found out that she had gone off her meds, not on purpose, but they weren't available. And so, we worked out with the landlord. We figured out, what was going on with her medication. She finally was able to get medication, went back on it, but we were able to help her avoid eviction, because that's what the landlord wanted to do, is evict her because of what had happened. And, we had to explain medication wasn't available. And once we were able to do that, they didn't move forward with an eviction, and she was able to keep her housing. So one of the questions we get a lot is, by landlords, is what do we do when, a tenant just, is hoarding, or, their apartment is just so dirty. It's, maybe infested with roaches or bugs, bed bugs, something. And the landlord wants to evict the tenant because of that. And so the next case, Douglas versus Creeksfield Corporation, the landlord attempted to evict the tenant, and the rationale was the tenant's unit was very unsanitary, but the tenant had a mental disability, and the tenant asked for an accommodation to get more time to clean her unit, because she was going to get the assistance of a social service agency to come in and help her clean the unit, but it was going to take some time. And the landlord denied the accommodation and moved forward with the eviction. And not only did they move forward with the eviction, but in the trial court, the court's decision was that was okay. And so the tenant's attorney appealed to the Court of Appeals, and the Court of Appeals found that both the landlord and the trial court, in refusing to consider the tenant's accommodation, broke the law. And they should have, both the court and the landlord should have considered her accommodation request and not evicted her. And so that's one of the few times that an appeal actually works, because typically it's really hard to overturn any kind of decision by the court. But in this case, they were able to do it, and the appeals court overturned the decision of the trial court, because the trial court had confirmed that it was okay for the landlord to evict the tenant due to the unsanitary condition of her apartment. So I think that's a really interesting case. And we hear from other advocates all the time that, what do we do? There's, somebody who has is a hoarder and has, is in danger of getting evicted because they won't clean their apartment or get rid of things. And so I think, they could ask for an accommodation to not be evicted if they're able to get assistance to get their apartment cleaned out. And so I think that's, a really important case to consider. And here's my contact information. You can contact me through our website by asking a question or reporting an incident. The quickest way to get a response, though, is to email me. And there's my email there at the bottom. And so now I want to see if there's any questions from folks about anything I've talked about.
Yeah, you know what, Francis, first of all, I think if I could go to the next slide, I know we're early, but I want to go ahead and go over the CEUs, because then I can give you a little bit of a chance to look through the chat while I'm doing that.
Okay.
So for any of you that are joining us today, well, first of all, thank you all for joining us today. But if any of you are joining us today looking for CEUs or certificate of attendance, please understand that we're set up to provide licensed social workers and licensed professional counselors in the state of Texas with CEUs. If you have a different license in Texas, or you have a license outside of Texas, you're more than welcome to go through the same process, get a certificate. Excuse me, I'm so sorry. Provide that to your jurisdiction and see if they'll accept it. But just please note that there's no guarantee, unless you're with the two organs, the social worker or an LPC in the state of Texas. So the certificate, today's webinar is worth an hour and a half worth of the CEU credits. You must complete the entire webinar live or recorded. I'm sorry, not live, not recorded. That shouldn't be in there. We used to do 2 a day on another thing, and I apologize. That shouldn't be in there. But live, in order to be eligible for CEUs, you must complete the Google survey. That should pop up as you close out of Zoom today. If it doesn't, you will also get a link to the Google survey in the follow-up email I will be sending out. The survey link will be open for a week until 8/2 August, and please give me about a month. And I apologize to those of you. I am behind even from last month, and so I apologize, but we still are working on those, and we will get those out. So that being said, the other thing too is we will be getting this this webinar, like all the other ones. We will be getting the recordings uploaded to the YouTube channel and available to you. And like any other recordings on our YouTube channel, if you go into the section under the recording, you will see that I also put the link to the slides in most of those. Now, some of the early years we didn't. I'm not sure we did that. I tried to go back and catch up on some of them. I haven't gotten all of them, but you should see the same link that I put in the chat today in that in YouTube under the video, where you can download the slides and take notes on them or do whatever you'd like to do. Share them with anybody, and not only that, but please help us get the word out about all of this stuff. You know, our goal is to help as many people as we can, and you guys can really help us spread the word. And I did see someone's question about earlier that I tried to answer about Janet's question about legal resources. I gave some of those for the DFW area. There are fair housing organizations that really cover the entire state, and I think there's also low-income legal aid organizations I know that cover the state of Texas, but I think even across the country. But those will have some of the resources you need. We have a Texas Tenants Unit in addition to the North Texas Fair Housing Center that cover Dallas. And I think the Texas Tenant Union, Jen, I'm pretty sure they cover Collin County as well. And also the Legal Aid of Northwest Texas office in McKinney would cover Collin County. So Francis, I'm gonna let you answer questions if you'd like. Okay.
So the first question is, somebody asked who moved. You are the tiger owner. and I use that. No, actually, it was my office location, and another tenant in our office building was talking about he had a pet tiger, and he even went to the extent of I don't know, he said something about maybe removing its vocal cords or something so it wouldn't make noise. But anyways, the whole thing was just really, really sad. And, he didn't have anything to do with us. He ran his own business, had his own office space there. But that was just to give the example that, if you were asking for an accommodation to have a tiger, it would be rightfully denied because you shouldn't be owning a wild tiger anyway under law. So but no, that was not mine. It was another tenant in our office space building.
Francis, I have a real quick question for you, well, I'll let you answer your question first. I've one, but
okay, yeah. And then the next one is, says, let's say the accommodation is made for an emotional support animal. Can tenants be asked to pay a deposit or pet rent? No. So in addition to an accommodation being in addition to it being a request to be exempt from a no pet policy, it also should be an exemption for any pet deposit or pet rent. So if the animal is an emotional support animal and not a pet, then they should be exempt from all of those things. So from a no pet policy, from pet rent and pet deposit.
Francis, on that note, if someone already moved into the apartment, didn't realize this exemption existed, and moved in with an animal, paid the pet deposit, had been paying rent with the pet, and now understands that they could have known about this accommodation, can they go in and get their deposit back and maybe stop the pet rent at this point, or I guess best case scenario, get the pet rent back?
Yeah, they can make a request once they do the accommodation request and it's approved for the emotional support animal or service animal. Then the next part of that is they can request their deposit back and any pet rent they've paid. That's a little bit harder to do because a lot of times the apartment doesn't want to give it back. And they may have an argument for keeping it because the person didn't initially ask for that accommodation request. And, unfortunately, under, all laws, lack of knowledge of the law is not an excuse for anything. So
but would it be a reasonable, would you see it as a reasonable request and a likely of at least stopping the future pet rent and getting the deposit back?
So it will definitely stop future pet rent. And I think the easier thing would be to get the deposit back. It might be harder to get the pet rent that's already been paid each month. We can advocate that they return both. But the easier one to get back is going to be the deposit. And then of course, and the one that's, easiest is that once the accommodation is granted, moving forward, they don't have to pay pet rent anymore. And if that means, adjusting the lease language and signing it again, that may have to happen, or doing an addendum to the lease that, they don't have to pay pet rent anymore. Somebody asked, let's see, I work at HUD housing units in NC. I guess that's North Carolina, right?
I'm assuming that's right, yes.
Birds or gerbils, rodents and can move in with residents. We only require pet deposits for cats and dogs. If someone has a service or emotional support dog, cat, those fees are waived provided the documentation is presented to management. Yep, that's exactly the right way to handle everything is, if somebody asks for that emotional support dog or cat, and it's management's right to request documentation in the form of, maybe a doctor's note, then yeah, that person, so Judith, you are handling everything exactly the right way.
Francis, can I have you back the slide up one so we have your contact information up while we go forward, and then you'll also get the her contact information follow-up email that I sent. But I have a question for you, if I could, about, as Aaron talks about the homeowners associations in Texas, notorious for bad decisions. And I know that there was a law that was passed in this session to as a result of the homeowner association here over off 380 that had decided they were going to prevent any homeowners from renting to people on Section 8 vouchers, right? And
right.
you had said you were involved in that, and I know the law changed in Texas, but in addition to that, was there ever any other fair housing things that came about for if you were outside of Texas?
On that topic?
Yeah. In other words, I know that the state legislature went ahead and passed a law in Texas that you just can't, just homeowners associations cannot discriminate or against sources of income, force people that live in the homeowner association discriminate against people on the basis of source of funds. Is that right?
Yeah, so right. So homeowners associations are pretty notorious for trying to tell their owners who they can and can't rent to, because as you all know, if you buy a condo, you live in it. Some HOAs have a requirement you have to live in it for at least 1 year and then you can rent it, or some of them have, if you buy it, you have to get the HOA's permission to rent it and you have to follow their rules. Well, there was a big case in Denton County where an HOA decided to prohibit their owners from renting to people with housing choice vouchers or Section 8 vouchers. Because that particular HOA, there were a lot of people on Section 8 living there, it would have really meant like mass evictions.
And they gave the landlords 30 days to move everybody out.
They were trying to force landlords to evict their tenants even before their leases were up. So advocates got involved, and they initially backed down on that piece of evicting everybody within 30 days. And they said, as you can let people, if they're in a lease, let them live there until their lease is up, and then you have to evict them because they're not renew their lease, because they didn't want the owners to be renting to housing choice voucher holders anymore. So in this last legislative session, surprisingly, the state passed a law that made that illegal, and specifically on the issue of housing choice vouchers. So HOAs cannot prohibit people, owners, from renting to housing choice voucher holders or Section 8 voucher holders. So that's illegal now. What that HOA in Denton County was doing is now illegal. So, excuse me.
Bless you.
So I don't know how that case is going to resolve, but a lot of tenants filed with HUD.
Yeah.
So at some point, there's probably going to be a settlement, because now the HOA is in direct violation of that new law, because that new law doesn't grandfather anything in.
And
but
so
yeah,
the homeowners association will likely end up being liable. Is that correct?
Yeah, they'll probably, because I can imagine the tenants are not gonna, because a lot of people were damaged by what happened. And some owners did just evict their tenants. It wasn't, they were scared, they were worried, they were scared. The HOA was threatening a per day fee for any owners who were not in compliance. And so some people did get evicted and had damage. So I'm sure there's going to be, eventually down the line, there's going to be a monetary settlement of that case.
And unfortunately, in Texas, homeowner associations have historically had crazy ground rule rights, and they fine their people, and so people have every right to be afraid.
Yeah, and if you do have an HOA, and this is, I know there are HOAs in neighborhoods that are for single family homes. Those tend to be a little different, but the HOAs for condominiums and townhomes, whatever, be aware too that a lot of them, if they were built before 1988, which is when the Fair Housing Amendments Act included disability and familial status, if they were built before that, a lot of them have provisions in their rules for the HOA that you're not allowed to have children in there, or anybody under 18. And then in 1988, the Fair Housing Amendments Act, including, that included disability, also, like I said earlier, included familial status. So now those provisions are illegal. they can't say you can't have children in an HOA at a condo, for example. And
But-
I don't know if that, we see it a lot because their their HOA, what they call them, what, CCNRs or rules, whatever, they predate 1988. So we see a lot in there that if they wanted to try to keep their their townhomes or their condos just kind of, adults only, before 1988, they actually could do that, but now they can't anymore. And the language, and a lot of them aren't enforcing it, but the language is still in there and it should be taken out.
Yeah. But that does not include the 60 and older restrictions for senior housing, right?
No,
Yeah.
the senior housing is the one exception to the rule of allowing children of they are allowed to say no children if it's a designated senior building, which is what, usually 62 and over. Some are 55 plus, I think, too.
I didn't know if you looked at my list of where to find resources for legal aid, and I know you weren't necessarily just pertaining, probably, Janet, to asking about for low-income people, but I gave her your organization, Texas Tenants Union Legal Aid of Northwest Texas. I didn't know if you had somebody else you wanted to add to that list.
No, I don't have anybody else. And,
Okay.
one of the things is it's not just a document or a form to stop an eviction. You actually have to file a lawsuit. You actually have to file a discrimination lawsuit and then use that as the basis for an injunction to stop an eviction in state court. So it's a process, and it has, typically it's going to have to be done by an attorney because it's a filing. It's not like a standard document that you fill out. And the discrimination case has to be filed to support the stopping of the eviction in the other court. And typically, the discrimination case is going to be filed in federal court. And then you use that as the basis to file an injunction in the civil court, in the state court, which has the eviction, which is usually the justice of the peace court. So then you have two filings going on. You have a discrimination case in federal court, and then, your eviction in state court, but you have to use one to stop the other. I've only done that once, and that was in California, and we actually got the eviction stopped, and then we were able to settle the discrimination case and then use that to dismiss the eviction ultimately. But it's a lot of legal work, so really you need an attorney that's going to be able to do that for you.
And please note, the biggest issue we have with people, especially with evictions, is coming to us at the last minute after they've already missed a date. They didn't show up to court for their hearing with the justice of the peace. All sorts of mistakes have been made, and then trying to track backwards is so incredibly difficult, and in many cases impossible, because organizations like Francis organizations, they get calls all the time. They just can't drop. It's very difficult to just drop everything for one person, depending on what the load is that they're carrying. So please help us educate people on, don't wait. As soon as they get that eviction notice or whatever, reach out to someone, and the sooner they get started is going to help their case a whole lot.
Yeah, because we unfortunately get a fair amount of people who call us after they get the eviction paperwork from the court that it's been filed against them. Or a lot of times we get a fair amount of people who have already had a decision in eviction court. And, if they haven't made an appeal and you only have 5 days to appeal that decision, you pretty much can't do anything about it. So it's just real hard, but whoever said that is right. Like, we really need to inform people that they need to reach out for information and assistance as soon as possible. So somebody asked, with discrimination, can you explain how the phrase decent, safe, sanitary, and in good repair is used by landlord against tenant sometimes, but HUD uses this phrase for the landlords? How can we better interpret this phrase for both? I'm not sure, because, from a landlord's point of view, yeah, they, if they feel the tenant isn't keeping their housing sanitary, they could try to evict the person. And HUD specifically for, I think the Housing Choice Voucher Program, they do inspections of the housing to make sure it's in, decent, safe, sanitary, and good repair. And they'll tell the housing provider if they need to, fix anything or repair anything before the tenant moves in. But I don't know. I think you just, you have to interpret it differently for both. And then I think the way to address it is different for each side as well. Like, for the tenant who's maybe being evicted or asked to move because the place is too unsanitary, you can maybe go the route of an accommodation request if the tenant's willing to clean up the apartment, or has, can get an organization or social service group, whoever, to help clean the apartment. So that's a different path than, if the apartment isn't in good repair and the landlord should be on the hook. That's a whole different area of law regarding repairs that, a tenant would have to pursue. And I think, the important thing to remember there is that there really isn't any good reason for a tenant to stop paying rent. So, I use the example of, the roof could be falling in on you, but you still don't have the right to withhold your rent. You have to pursue other remedies to get those repairs made. But, never stop paying your rent because you think there's a repair issue that justifies you not paying your rent. I hope that helps. I'm not exactly sure if that was addressing that question.
I'm trying to get the number for Spencer at the state of Texas for your question about 811. But just so you know, 811 vouchers in Texas are all through the state of Texas. The state of Texas was awarded funding from 811, and it took them several years to work out how they were going to do that program. And it subsequently ended up with vouchers that are totally accessed through TDHCA, Texas Department of Housing and Community Affairs. I do not know, and I do know that the state has their own agreements with each landlord, with the landlords, about accepting of the Section 811 voucher. So I don't know if there's rules based on that, the state's program, that allow them to discontinue the program because someone didn't do what they were supposed to do, and that somehow leads to a quicker eviction. I'm not necessarily sure exactly what you're referring to, Janet. I'd be happy to talk to you about that, but I'm going to get you the TDHCA number or email address for Spencer here in just a second.
So somebody asked, Marty, can you do an instructional webinar on understanding eviction process and step-by-step appeal and to protect yourself? So that is one of the topics that I've presented before. Yep. So that's definitely something we can do. And one of the things I would
do that, but it's also recorded on our
oh, yeah.
You can access any of the previous webinars we've done on our YouTube channel, and as you get the follow-up email, if you ever, any email I send out if you look under my address and stuff, you'll see the link to our Facebook page and the link to our YouTube channel. And if you go there, you will see the recording of the one we did. And once again, as I was saying earlier, if it's on YouTube, if you look under the recording in the notes section, you should see a link to download the slides and take notes just like you would, like we're doing today. I don't know how long, I don't recall how long it's been since we've done that topic. If it's been over a year, we can surely put that on our schedule again.
Yeah, and one of the things I was going to ask of all of you is, what topics do you want to see in future months? If you have suggestions or things you want us to do housing related, send me an email. I still have the slide up on the screen with my email address. We're always looking to, we want to make sure that we're giving people the information that they need. So if you have any suggestions or there's topics you want us to review, just let us know. And I'm happy to. I don't know. I'd have to look up, Marty, too, when we did the last one on eviction, but it might be time again to do that.
Yeah, it might. That's why I was saying that if it's been a year, we definitely could do that again. We like to wait at least 12 months. We're still trying to figure out our topic for August, and if it's been a year, we surely could look at that as being a topic we do again. I am putting Spencer, the link to the 811 program with TDHCA, and Spencer Duran is the director. There's program coordinators, but please reach out to them directly and see if they might be able to help you.
Mm-hmm. And I think I covered everything, although everything that was a question on the chat. And I think we're right. We're right on time right now, so I think that's good.
You want to, yeah, stretch all the typically. Okay.
Did I miss anything, Marty?
Janet, I hope you just got my link. I put Spencer's information in the and obviously that depends on whether it's a rule issue with the tenant and the 811 program, or whether it's a actual landlord issue with the tenant. And I think how they getting evicted would probably have something to do with the basis of which are they getting kicked out of the 811 program, or are they actually getting evicted from the apartment for something in their lease. And when they are in programs like that, there's two different ways that I mean, depending on, like I said, what the issue is, that could happen. Oh, very good. Okay, I'm sorry, I was going through real quick trying to make sure I didn't miss anything. But yeah. I mean, there's obviously a variety of landlords across Texas in regards to the spectrum of professionalism, if I can say that better. But also, as we say in most everything we do, please, you all advocate for tenants' rights with your local political representatives, and please, the people you serve, get them to do the same. Texas is a very landlord-friendly state. We're never going to overcome that if we don't come out and force and make our elected officials know that tenants' rights are important to us. So, Francis, thank you very much.
Oh, of course. And I'm interested to, everyone, please do the survey, because I'm interested to find out, when I talk about cases, it gets me really revved up, but it could be completely boring to my audience. So, give me your feedback on this, because if people loved it, we can, do review of other areas, but if not, we'll move on to something else.
Well, there's two things about that. I think number one, the topic as it comes across on a flyer, and part of it's hard to know because we're in the midst of summer. We don't get as many people that register because it seems like more of a educational type thing as opposed to how does this pertain to my landlord evicting me tomorrow and I don't have a place to live, kind of thing, urgent, personal. But when you get into the topics, it gives you information to help people that you serve. And so we will work on some more of these. I think it's really important and for everybody to kind of know and feel confident about when they're trying to advise their clients. They can't, the landlord cannot do that to you. I know he cannot do that to you. We need to fight this as opposed to pushing them down an avenue that's just a waste of their time,
Yeah.
So you guys, thank you so much. Francis, thank you very much. And Francis, I'll get back with you and we'll figure out a topic, what we can do for next month. And
Okay.
so look forward to our flyer for next month, y'all.
Thank you, everybody.
Thank you all and have a wonderful day, y'all.